All right then. Good morning, everyone. This is Christmas Eve, and this is a special meeting of the members of the State Liquor Authority. Present today, or participating today, are Chairman Bradley by telephone.
Yes, I'm here.
We have on video Commissioner Fan and Commissioner Ford. We have staff in attendance, General Counsel Meyerhoff by video, and myself, Secretary Downey, in the Albany offices. We have 4 items on today's calendar. One is a matter that was on Tuesday's regular full board meeting. It was held over. The other 3 are licensees who have made Santa's naughty list. So we will start first with item 1900, which is Westchester OP 1322304. This is Cafe Tacuba of Yonkers, Inc. This is the matter that was held over from the December 22nd meeting. It's a matter that went to hearing. The license has been summarily suspended since October 30th.
Yeah, thank you, Tom. The counsel's office asked that we adjourn the case because it was put on the calendar the day before the Tuesday meeting, and I hadn't had an opportunity to review the decision with my prosecutor on the case. There were a number of charges that were dismissed on what appear to have been minor pleading technicalities that we could address through an amended pleading. I think there are about 5 charges that were into that category. And I wanted to reflect on whether we should take the time to do that, knowing that that needed to be balanced against the need to give the licensee, whose license is suspended, a prompt hearing and resolution to their matter. Based on that analysis, counsel's office has decided not to amend the pleading and to let those charges go, even though we believe the evidence in support of them was presented at the hearing, and there would not need to be more hearing time to get them sustained. So there is one charge, however, that we believe, based on the record before you, should be sustained, even though the ALJ dismissed it. That is charge number 2, which concerns smoking in violation of Westchester County local regulations, specifically smoking hookah, which is illegal in Westchester County. Note for the record that as the hearing decision reflects, this charge was based in part on a summons that was issued by local Westchester law enforcement. That was not the creation of an SLA investigator on their own. The summons itself, which was put into evidence as Exhibit 2 and referenced in the ALJ's decision, expressly cites the section of the Westchester Code that makes hookah smoking illegal, Section 534, which is the Westchester Smoke-Free Worksite Law. For some reason, in the ALJ's opinion, even though she cites that section in her discussion of the facts and evidence, when ruling on charge 2, she turns to a different section of Westchester County law, Section 873.2021(5), which does concern restrictions on smoking, but on nicotine smoking, and dismisses the charge because that section does not describe that hookah smoking is illegal. She's correct about that, but she's relying on the wrong section. The section that the charge was made on and the basis for it is in the record, in the evidence, and in the hearing decision. It's Section 534, which we've provided to the members in advance of the meeting, and that is what restricts smoking in all places of employment in Westchester. Places of employment are defined expressly to also include, quote, indoor and outdoor areas of restaurants and bars, end quote. And the definition of smoking and the smoking that's prohibited under the statute includes the inhaling, exhaling, burning, or carrying of any lighted or heated, and then it discusses tobacco first, and then says, or plant product intended for inhalation, including hookahs, whether natural or synthetic, in any manner or in any form. We believe that this is just a legal mistake that the ALJ, or an oversight, and not a question of a lack of evidence, and suggest that that charge can be sustained, charge 2. With that said, the rest of the hearing decision stands as is and is up for the board to consider discipline. Thanks.
And just, you would not need to send this back to the ALJ. If you were inclined to sustain that charge, you could do it based on the arguments presented by counsel and the record that's before you.
Yes, that's what we're saying. Thank you. Thank you, Tom.
All right, then, Commissioner Fan.
Based on council's advice, I will sustain charge 2. And I am going to set the penalty at $15,000.
And just for the record, you'd also be adopting the other charges that were sustained by the ALJ, which are 1, 8, 9, 12, and 14.
Yes, thank you.
All right, then, Commissioner Ford.
I'm going to vote for exactly the same decision as Commissioner Fan.
And Chairman Bradley.
Sustain charge 2 and then sustain the charges sustained by the ALJ in the decision, and $15,000.
All right, then. The next item, and this is a request for a summary order of suspension, is 1901. It is Queens OP 1237086, Il Baca Restaurant, Inc.
Good morning, members of the board. Michael Amarato from the Office of Counsel respectfully submits the Il Baca Restaurant, Inc., located at 253-24 Northern Boulevard, to the members of the authority to consider an emergency order suspension of their retail license pursuant to 401.3 of SAPA. This license was issued on October 8th, 2010 to operate as a restaurant. The sole principal is Joseph Opie Desano. It's a 3-story freestanding building in a mixed-use area. NYPD and the Vice SLA COVID Task Force were made aware of complaints that on December 9, 2020, the licensed premises hosted a party with approximately 50 patrons. They were made aware that there was dancing, there were unmasked patrons touching each other, forming a conga line and going around the room, standing without masks and not social distancing. So in connection with that complaint, an investigation was conducted on December 22nd, 2020. And at that time, the EO 202.81 went into effect, which prohibited inside dining in the New York City area. When SLA investigator Strivali and the task force entered the premises to conduct an inspection, they went up to the rooftop. And when they got to the rooftop, they observed 3 occupied tables. 3 tables, one table had 4 patrons, one table had 2 patrons, and another table had 2 patrons. All of them were eating and drinking. This rooftop was fully enclosed glassed window walls, as well as a roof, canvas retractable style roof, but that was fully closed as well. This created an indoor dining experience, which is currently prohibited under 202.81. Okay. In addition to the EO violations, investigator Strivali identified at least 6 fire and life safety issues, including but not limiting to propane tanks not stored properly, fire extinguishers not inspected monthly, defective emergency lights, no flame-proof affidavit for the drapes, and blocked exits. So the licensee, in addition to being charged with being in violation of the executive order, is also being charged with failure to comply with building and fire code violations. Now, during the course of this inspection, investigator Strivali had spoken with the licensee's daughter, Tina Marie Desano, who then later appeared at the premises with her brother. Also with them was a individual by the name of George Santos. George Santos identified himself as a individual who ran for congressman for the 3rd District, and also was at the alleged party on December 9th. And he confirmed that individuals that were at the party stood up, started to dance. He said some weren't wearing masks. He said, and they formed a conga line, and that's what had happened. Tina Marie, the daughter of the licensee, she was the manager. She said that she brought the guest up to the banquet room where this party was being held, and she had repeated time and time again that she could not act as a police officer. She cannot act as their parents. She cannot act as a chaperone. That she basically had no control over her patrons. Right. Now, this conversation about the alleged party on December 9th was all videotaped by Charlie Investigator Stravali, and these individuals were made aware that they were being videotaped. So with respect to the video that was provided to you by counsel's office, we feel that there's a substantial foundation for that evidence to be used in connection with the summary suspension proceedings. Now, in addition to Tina Marie's admission about the party, she was also very quick to admit that she was a strong advocate for the restaurants in the New York City areas and how they were being gravely affected by the restrictions placed on them. In fact, there was a lawsuit lodged against the governor, the attorney general, and Bill de Blasio in connection with these very restrictions. Included in that lawsuit, Tina Marie Opadisano included an affidavit, and this is going back in October 1st. So she was well aware of what was coming before her. She knew that the cold weather was about to come on, and she knew how that was going to affect her business. But she decided to put profits over the legal compliance and potential consequences, and she did. And she allowed and she permitted the party to occur on December 9th, which included the conga line and people dancing without masks and at social distancing. And she also permitted the indoor dining experience that Investigator Stravali and the task force observed when they were there on December 22nd. Now, this licensee and manager demonstrated total disregard for the health, safety, and welfare of the patrons and employees by disregarding the executive orders. On December 9th, the patrons were standing, not social distancing, touching each other in a conga line, not wearing masks. And then even after knowing about that video that was taken that night, she knew that video had gone viral. They continued to ignore the executive orders, particularly 202.81, by allowing indoor dining for their patrons in a completely enclosed rooftop deck on December 22nd. Now, this conduct in the midst of this COVID pandemic is reprehensible and should not be tolerated. A conga line and dancing is an insult to all of those who have experienced COVID and survived. And it's an even greater insult to the families who have buried loved ones as a result of this pandemic. What has this management done to make you believe that the licensee can be trusted with a liquor license? I submit to you, nothing. The manager admittedly said that she is not a police officer, she's not a babysitter, she's not a chaperone, and she cannot control the patrons. Therefore, council respectfully requests that the board summarily suspends this liquor license. Thank you.
Thanks, Mike. I just want to add that the lawsuit that was filed in connection with the inside service rules. The reason we mention it is not for any reason other than to note that this licensee particularly was aware and admitted their knowledge and involvement of the restrictions in place, and with that knowledge, we had these two incidents that Mike introduced to the board. Thank you.
With that, Commissioner Fan, do you have any questions?
No, thank you, Mike. I don't have any questions.
Thank you.
Commissioner Ford, do you have any questions?
Yeah, Mike, this rooftop area, it's a part of their licensed premises under normal
Yes.
circumstances?
Yes, Commissioner, it is licensed. I will say that the windows, along with the roof, are fully retractable. But according to Investigator Stravali and the task force, at the time of the inspection, everything was fully closed. In fact, when Investigator Stravali had spoken with Tina Marie on the phone, she demanded her employees to immediately open the windows, at which point Stravali said, what's done is done. The inspection has already been concluded.
Is she on the license, manager or otherwise?
She's not on the license.
Okay.
Just as manager, as the manager.
She's not. Okay.
Just for the record, she identifies herself as the owner in the affidavit, and there's some question of availing that we will either charge or continue to investigate and then consider charging.
Because her father, who is the licensee, is apparently very sick or something like that. That was claimed.
They said he had a plane accident.
Yes, he had a plane accident, but the affidavit in which she identifies herself as the owner actually predates that accident.
Interesting. Any other adverse history, Michael?
Years, there was one case for a charge for noise where they paid a $2,500 penalty.
Thank you, sir. No other questions.
Chairman Bradley, any questions?
No, I have no questions.
All right, then I'll ask for the vote of the members. First, Commissioner Fan.
It's clear that this licensee and his managers and other people he's trusted are creating imminent threat to public health, safety, and welfare by not following the governor's executive order surrounding COVID-19. This location is a threat to public health, safety, and welfare again, and I'm voting to summarily suspend this license.
Commissioner Ford.
Based on evidence presented by counsel and the fact that I think there's a lot more going on here than we just may have scratched the surface, I'm going to vote to summarily suspend.
Chairman Bradley.
I'm going to vote to summarily suspend. Based on council's presentation, it's clear that even when this licensee has publicly violated the governor's executive orders, they continue to intend to do so even after the video went viral. So they're clearly a public health safety risk.
All right, then.
Thank you.
The next item I have is 1902. New York OP 1167354. The licensee is Wolf at Tribeca Inc.
Good morning, members. Robert Buckley for Council's Office. The item that Secretary Donahue mentioned has a trade name, Wolfgang's Steakhouse, located at 407, 411 Greenwich Street in Tribeca, in Manhattan, in the city of New York. It has a full liquor license. It was licensed as a restaurant, licensed initially on July 20th of 2006. There's no adjudicated adverse history. There was a prior executive order visit by Investigator McKenna on 11/15 when she found kitchen employees not wearing face coverings properly, and that matter's been notice for a pleading, and the licensee is pled not guilty by counsel. Investigator McKenna has returned to this location this past Tuesday, the 22nd of December, 2020, during the 9 o'clock hour. Indoor dining has been prohibited in the city of New York by Executive Order 202.81 since Monday, December 14, 2020. On this occasion of 2 days ago, Investigator McKenna observed a structure outside the location, which is a straight line with, it appears that there was some thought and labor attended to this structure, since there was space heaters and lighting. As the members can see, there's a peaked plywood roof, and inside the location there were tables set up, and there was 12 patrons dining at 6 tables. From the photographs, it appears most of the patrons were not wearing face coverings, but again, they appeared to be in dining. In any event, Investigator McKenna found that the structure did not have appropriate ventilation pursuant to Executive Order 202.38, which first allowed outdoor dining, and the attendant DOH guidelines, who have been on the State Liquor Authority's website for the past 6 months. And the relevant guidelines are that there be at least 2 sides open for proper ventilation. In this case, there was not. There was, again, as you can see from the report of the investigator and the photographs that he took, there were not proper openings, and that there were some gaps that they're covered by tarp. So again, since the structure appears to be not something that was just hastily constructed, it would seem that the licensee has no intention of stop using this structure, which in essence is indoor dining, but just situated on the sidewalk or road. So in violation of the executive, so the licensee is in violation of these executive orders. And again, since there's no indication the licensee is going to stop using this, the structure is in essence violating the executive order, and the governor articulated the reasons why he issued an executive order banning indoor dining in the city of New York with the increase in hospital admissions and positivity rates. So on that basis, the council's office dismissed it to the members for emergency order of summary suspension.
Thank you, Bob. Let me just add that I think, as you can see from the pictures, it's possible that there was a point at which the structure was open and perhaps compliant with outside service, because it seems to have been closed up by some plastic and the like. So the operator apparently took steps in the process of taking steps to shield customers from cold weather, has essentially completely enclosed it and created an inside space. Thank you.
All right, with that, Commissioner Fan, do you have any questions?
Mr. Buckley, can I ask you a question? In the report, there is, I don't know why I can't open this. It's not coming up for me. Sorry, I can't make it big enough for me to see it. Now, hold on a second. Let me just see. Sorry about that. So I can't get the screen to look. Sorry. I can't get the screen to show me the report properly. But anyway, I'm just going to paraphrase it. It said something along the lines of like the manager said the divider was blown closed.
Yes, both the plastic dividers were in a closed position at time of inspection. The manager stated that the wind blew the divider closed. When the divider was in closed position, blocking openings in the side of the structure, there was still a gap above and below the divider, providing a small opening into the structure. But again, it seems to be, again, even if this, the divider was open, again, it did not seem to be compliant with DOH guidelines requiring at least 2 openings, again, with the fact that there's a fixed roof, apparently a fixed roof.
So I don't get a sense that any of the law has anything to do with the roof. Is that right, or is that not right? I thought the law has to do with the opening of the sides. Is that not accurate?
I just mentioned
if
that
I may,
there
Bob,
is a fixed roof. Yeah, go ahead. I'm sorry.
If I may,
Go ahead.
the way the Department of Health guidance is phrased, it discusses a cover. It says that an outside space can be covered as long as there are 2 open sides. So we've interpreted that to mean that there be a cover. If there is a cover, there needs to be 2 open sides. So whether that's a permanent roof or a temporary roof, the DOH guidance even says it could be permanent or temporary. But we do think that's relevant for that purpose.
Okay, so our interpretation is that the roof is okay, but 2 sides needed to be open. And so, Mr. Buckley, can I just go back to my question, because I hadn't actually asked my question yet? If the divider that they're referring to, that the manager is saying that was blown close, if that was not blown close, would this have been allowable, or we're still closed on 3 sides?
Yeah, I would say that the DOH guidelines were not complied with, and that there was not 2 openings, and sufficient openings, not just, openings themselves. Again, because you can see from the structure, there appear to be some windows that could be slid open. So even that, to that extent, I believe that the DOH guidelines, or I'm going to leave it to the members to interpret, but my argument would be that the DOH guidelines would contemplates sufficient ventilation. Again, when the guidelines were initially issued in June of 2020, perhaps there wasn't enough thought about what was going to happen when the colder weather comes. Now it's here. But the fact remains that that does not appear to be, in this instance, proper ventilation.
Bob, can you hold on just for a second? We
Absolutely.
lost the chairman just about 10 seconds ago. I'm sorry to interrupt, but
No, sorry.
let's just give him a chance to call back. All right, Chairman, we have you back?
Yeah, I didn't miss anything. Go ahead.
Okay.
Commissioner Van, do you still have a question, or should I keep going?
Right. So your answer to my question was that it was closed on 3 sides anyway, so it really didn't matter that the divider is blown closed or whatever, right? That's the answer?
In the essence, the determination is, was there proper ventilation? For example,
Mr. Buckley, she's asking you a factual question. Was the enclosure closed on 3 sides?
yes.
Okay.
Yes.
All right. Thank you.
All right, Commissioner Ford, do you have any questions?
Yeah, I'm looking at the one picture with the plastic. It looks like it's covered over the windows or some type of opening. So it looks to me like even if those were uncovered, I was asking myself, would that remedy the situation? But it looks like not. I mean, because the other sides are still enclosed. Would that be a proper assessment, Mr. Buckley?
Yes, as Investigators McKenna reports, that there was, long sides down on the street side, and then shorter sides on either side of this structure. And then there's some, obviously facing the premises, appears to be tarp that's covering a majority of that side that are joining the premises.
Yeah, I can see that.
Yeah, Commissioner Ford, I'm on the same page with you. Like, if the windows were open, would that have been okay? I wonder about that. So
Let me address that. The answer to that would be no. We've not interpreted
it would not have been okay.
having windows for the same reason that windows in a regular restaurant do not make it an outside space. The fact that the structure happens to be on the curb as opposed to in the building, windows wouldn't be sufficient. I also think that the members should consider whether to credit the licensee's excuse or explanation for having that particular side closed when it is obvious from the structure that you're seeing in the pictures that that same licensee took steps to close off the openings that existed in this structure and serve in that location.
I was asking counsel because regardless of how this turns out today, I was looking to see, is that an easy remedy for this licensee to just open things up? But it looks like it's a little bit more involved than that.
Well, it does look like they had openings on the 2 long sides
Mm-hmm.
that have now been sealed.
Yep.
So this structure is, I can't say that this would be true of all the structures that are, that may come before the board, but this one appears to have been created with openings that would permit outside service under the DOH guidance, but had been closed off.
Okay. Okay. I don't have any further questions.
I asked Investigator Sergeant McKenna if he knew when the structure was erected, and he didn't ask that question, or he didn't know if that's relevant at all.
All right, Chairman Bradley, do you have any questions?
I have no questions.
All right, with that, I'm going to call for the vote of the members. First, Commissioner Fan.
Given the evidence presented by Council Buckley, this location is presenting a threat to public health, safety, and welfare, and I vote to summarily suspend this license.
Commissioner Ford.
Based on evidence presented by Council Buckley, I feel I have no other choice as well but to vote to summarily suspend this license for now.
Chairman Bradley.
Based on council's presentation, I vote to summarily suspend. Indoor dining is not allowed currently in New York City, and there's no question in my mind this is indoor dining, so therefore it's a risk to the public health, safety, and welfare.
All right, then the next item I have is 1903, Queens OP 1136386. Licensee is Sal and Vic Corp.
Good morning, members of the authority. Robert Buckley for Office of Counsel. The licensee that Secretary Donahue mentioned has the trade name Bella Via, located at 4746 Vernon Boulevard, Long Island City, the County of Queens, which is obviously in the City of New York. The license is issued as a restaurant since March 10th of 2003. There's no recent adverse history. The only adverse history was from 2007 for fruit flies or insects in bottles, which would no longer be a charge. There have been no other documented executive order warnings or violations cited against this licensee. Senior Investigator Jaworski visited the location this past Tuesday, December 22nd, 2020 in the 8 p.m. hour. And since the premises is on a corner, am I still here? Or
Yes.
Drop that? Oh, I'm sorry. Looked like I might have dropped that. Investigator Jaworski visited location. It's on a corner of Vernon Boulevard and 48th Avenue, again, Long Island City. Again, there was a structure which wrapped around the premises. There were 20 or so patrons eating and drinking inside the structure. Again, it was an enclosed structure with no openings. There was a slightly sloped roof, as the members can see from the investigator's report and photographs. There is, and again, it appears to be something that was constructed, with some thought and some labor. The name of the premises is on windows on the structure. Principal Salvatore Polito was present and showed the investigator that there were sliding doors, which when Investigator Jaworski was there were closed. Mr. Polito said that he would open the doors and said he would leave them open. And there were, again, two sliding doors, one on Vernon Boulevard and one 48th Avenue. Space heaters were provided, as well as lights suspended from the ceiling. But again, since December 14th of 2020, under Executive Order 202.81, indoor dining has been prohibited by the governor's order and by reasons why he articulated regarding the spike in the coronavirus. And 202.38, Executive Order 202.38 was issued by the governor allowing outdoor dining, but only if licensees comply with DOH guidelines. And one of the main guidelines for outdoor dining, if there be appropriate ventilation. In this case, with this structure enclosed, it is in essence indoor dining situated on an outdoor area. Again, Mr. Polito asked Investigator Jaworski how he would be in compliance. The licensee should have known, again, because these guidelines have been on the website since, for the past 6 months, and it doesn't seem that this licensee is planning to cease and desist use of this outdoor area, so continued use of the area will jeopardize the health, welfare, and safety of the public, and therefore council's request that the members contemplate an emergency order or summary suspension of the liquor license.
All right, with that, Commissioner Fan, do you have any questions?
No, I don't have any questions. Thank you.
Commissioner Ford, do you have any questions?
Yeah, Mr. Buckley, did you say when they were licensed?
March 10th, 2003, Commissioner Ford.
Oh,
With no adverse history other than fruit flies in 07.
thank you.
All right, Chairman Bradley, do you have any questions?
No, I don't have any questions.
All right, with that, I'll call for the vote of the members. First, Commissioner Fan.
It's unfortunate that this licensee is putting the patrons at risk by allowing them to dine in a completely closed fixture that is closed on 4 sides. This location is therefore an imminent threat to public health, safety, and welfare, and I vote to summarily suspend this license.
Commissioner Ford, your vote, please.
Based on the same reasons, I have to vote to summarily suspend as well.
All right, Chairman Bradley, your vote.
Based on council's presentation and the pictures submitted, it's clear that this is nothing but inside dining, and therefore inside dining, because inside dining is illegal in New York City at this point in time because of the coronavirus, this licensee has created a risk to the public health, safety, and welfare. So I vote
Right,
to
Chairman.
summarily.
Sorry.
Go ahead.
No, I cut you off. Go ahead. You finish your vote.
So I said I just vote to summarily suspend.
Chairman, I have nothing else on today's calendar. Do you have anything?
No, I don't. Just everybody have a great holiday, and we will talk soon, I'm sure. Thank you
All right,
all.
with that, the meeting is adjourned. Thank you.
Thank you,
Take care,
Tom. Thank you,
Take
everybody.
care.
Merry Christmas, everybody.
Happy holidays.
Happy holidays.